Hello and welcome. My name is Father William Maestri, and this is Overfed and Undernourished. Well, it's that time of year again when the United States Supreme Court goes through its annual identity crisis. It's not really sure if it is a federal court, the highest court, or whether it's a super legislative body, or a gathering of 9 social scientists or social engineers, or even delegates to a new constitutional convention, which some people believe every time they meet, there is indeed a new constitution that may very well emerge. Well, not to disappoint, on June the 15th, this past Monday, the United States Supreme Court decreed in the case of Bostic versus Clayton County that the 1964 Civil Rights Act, which was passed, specifically Title VII, which forbids discrimination on the basis of race, creed, color, and sex, that indeed it forgot to include in that particular categories or categories the lesbian, transgender, bisexual, and so on and so forth group, and that they too come under that particular protection of Title VII of the Civil Rights Act of 1964. Now, it ought to be noticed that in the 10 previous cases leading up to this particular decision, heard at the appellate level of federal courts, 30 judges who heard cases brought before them, that not a single one believed that that particular group came under the Civil Rights Act of 1964, Section 7. However, lo and behold, on June the 15th of this year, 2020, the court indeed found that they were to be included. This expansive understanding of sexuality, not male and female, but now gender, gender designation, which is an interesting concept itself, in which individuals now seem to be free to designate themselves as to how they wish to be identified. And I imagine that may be fluid as well and change from, I don't know, moment to moment, perhaps. And so, in spite of these previous appellate court rulings and findings, the Supreme Court found that indeed this particular group was covered by the Civil Rights Act, which reminds me, actually, of the story that Justice Antonin Scalia of blessed memory often told. It's the Prego story. Being an Italian American, he and his family loved to have, obviously, Italian dinners. And his mother was an excellent cook, and the father looked forward to it. And one evening, as they were having an Italian dinner and preparing for it, his father noticed that the usual ingredients that went into his mother's wonderful Italian sauce was not there, but he noticed a bottle of Prego. And being somewhat horrified at that, as they sat down and the spaghetti was laid out and the various other kinds of Italian dishes and the sauces were being poured on, his father asked, well, where's the tomato? Mother said, well, it's in there. Well, where's the garlic, and where's the onions, and where's the basil, and where's all of the other ingredients? And she said, oh, well, they're in there, just look for them. And Justice Scalia opined that, unfortunately, this is the way some jurisprudence is done. It's the Prego approach. Just look for it long enough, and you'll find it. And indeed, 6 justices of the Supreme Court, surprisingly, one of the newest members, Neil Gorsuch, and unfortunately, Chief Justice John Roberts, indeed applied the Prego standard of jurisprudence and found that indeed the 1964 Civil Rights Act did indeed cover these now groups of individuals. And if one goes back and reads the legislative intent, the debate, and all of the record from the legislature, one finds that this never came up. It was never mentioned at all in the legislation. By sex, they meant male and female. And but now it has been expanded. And Justice Gorsuch, who wrote the majority opinion, joined by 4 others on the court, there were 3 dissenters, Justice Thomas, Justice Kavanaugh, and Justice Alito. Justice Alito wrote a very powerful and unfortunately unanswered dissent by the majority, because frankly there is no answer to what took place other than simply judicial fiat, in which the court decided to be a kind of super legislature, and therefore they presented what they believed ought to be the legislation dating back to '64. Now, if one wants to amend legislation and wants to expand it, not by 6 members of the Supreme Court, but by where it originated, where it was debated, and where it belongs, it is in the legislative branch. The legislative branch of the Constitution is the first of the branches, and they're listed in order of importance: legislative, executive, and the third branch is the branch of the judiciary. That was considered the weakest branch of the government. As Alexander Hamilton indicated, they have neither sword nor purse. Well, that has certainly changed over the decades. And what Thomas Jefferson feared and had legendary battles with Chief Justice John Marshall over was this idea of judicial overreach. He was a lot less polite than that. Judicial tyranny, an oligarchy, a kind of despotism, whereby the people, which is the basis of a republican form of government, that ultimate power relies in the people. That's where it's vested. That it indeed would be handed over to a judiciary that indeed could make the Constitution anything it wanted. And Jefferson talked about the Constitution as becoming nothing but a kind of wax in the hands of the judiciary. That is, you can mold it and shape it any way that you want. And we saw this kind of Prego and wax molding take place in this decision with Bostic versus Clayton County. Because instead of remanding it to the legislature and saying, you fix it, include it if you want, explicitly indicate that it's not included, but that we as the court, the highest court in the land, we are not qualified and this is not our area of authority or influence. That did not happen. They took it upon themselves, the 6, to indeed expand clearly which was outside the bounds of the original intent of the legislation that was passed in 1964. And the appellate courts that heard similar cases, that is, that a person could be fired or dismissed from their job on the basis of their sexual orientation, they found that not to be at odds with the legislation that was passed by the Congress. But now, indeed, it is at odds, and therefore this particular group is now also protected by that clause, or that title, if you want, in the 1964 legislation. It's important to remember that this expansionism has been going on for quite some time and is deeply troubling. And it goes back to the notion of judicial review, which again was promulgated by Chief Justice John Marshall, who was a stout fervent Federalist appointed by John Adams just about 2 or 3 weeks before Thomas Jefferson took over as President of the United States. And Marshall and Jefferson were bitter enemies. Jefferson, like many, many of the founders and framers, was deeply suspicious and troubled by concentration of power in the hands of any one person or any one branch, because they understood human nature. And human nature has this drive for power and control and influence, and certainly it becomes magnified when placed inside of government. Individuals as well as particular bodies or groups within government. At stake is liberty, is freedom itself, and the republican form of government, where ultimate authority again resides in the people. But now Jefferson was greatly fearful that indeed the Constitution would become that wax that would simply be molded. And he warned about this extensively, and he and Marshall, and there have been many, many books, some recently, very, very good books, about the debate between this concentration of power that Marshall saw with judicial review. Judicial review indicates that all issues about the Constitution as to law reside solely through the interpretation of the United States Supreme Court. And they alone decide those particular issues. Jefferson was of a different mindset. Jefferson indicated that each of the branches, separate, co-equal, each had a stake in the Constitution, and each was qualified to determine the application and meaning of the Constitution as it related to its specific area of competence and authority. Therefore, the executive branch and the legislative branch were co-equal to the Supreme Court in terms of the interpretation and application of the Constitution. Now that, of course, is a minority view and has been a minority view as it has come down through the decades, I would say even the centuries, since all of this began really at the beginning of the 19th century, especially in the debates between President Jefferson and Chief Justice John Marshall. But there are serious issues that are raised here, especially as Justice Alito on the Supreme Court, who wrote the dissenting opinion, indicated. And he listed 7 of them. I'm not going to go over them, but the one that concerns me is the issue of religious freedom. And he says that this expansion of the 1964 civil rights, which he called legislation from the bench, it's legislation from the bench, which he feels, and I think rightfully so, is totally out of bounds for the authority of the United States Supreme Court. And Alito indicates that there's going to be a tremendous burden placed upon religious organizations in terms of speech and hiring, in terms of employment. But he specifically zeroed in on schools, where schools are not simply about reading, writing, and arithmetic, but they're also about character formation and the transmission of their beliefs and values, their moral teachings about how one should live and how one should act according to those teachings. And the school has a legitimate right to expect that those who indeed are employed by a religious institution, be it Catholic or what have you, that they would have a reasonable expectation that those who are employed would also convey those fundamental moral teachings to their students whom they influence, especially at such a formative age and a very critical age in the development of that person's thinking and character. And so Justice Alito was incredibly distressed by that. The National Conference of Catholic Bishops, the head of the conference, Archbishop Gomez from Los Angeles, also was deeply troubled, as he said, by this particular decision, because sex then is no longer male and female. It's no longer understood as a gift from God, but again, it is a kind of social construct. It is something that we have made up in the culture and in society, but does not reflect the plan of Almighty God. And also, the questions of science and biology are often very much ignored between a male and a female. And these kinds of judicial overreaches are the kinds of things that often wreak havoc in the society, because the law is unsettled. And the court itself admitted that. The law is unsettled, which means we're going to have more cases. And I'll give you a case in point to the cases that are coming. In October of 2020, when the Supreme Court opens its new term, in October of this year, there is a case of a Catholic organization who facilitates and engages in adoption. The city of Philadelphia has an adoption program. They have excluded Catholics from participating because Catholics do not facilitate or participate in adoption of children with same-sex couples. And they have been excluded on the basis of that. And that has found its way to the Supreme Court, which will have to be deciding this particular issue. And so we have the court more and more engaged in various disputes and settlements that should never have risen to that particular level. The court is not the best venue. It's not the best venue to decide these kinds of issues. When life begins, the nature of marriage, and now the questions of gender and sex, and all of the other kinds of issues that bubble up to the Supreme Court. It should be decided legislatively, not judiciously. And the executive branch is there to enforce whatever and carry out whatever the law is. But again, this is not the best venue. And what happens is we continually ferment division, culture wars, contentious behavior, and the whole development of a kind of commonwealth, a kind of commonweal, a common good, becomes more and more difficult to achieve because so much of our time and energy and resources are spent, if you want, in litigation and in aggravation against one another. Again, increasingly we have become comfortable on the battleground, and we have lost a great deal of sight as to the common ground. Now, so I think that it's very important that we consider this particular case, because again, it reflects a great deal more than just one particular case. It raises a number of significant issues that deserve serious adult attention, not simply by lawyers and judges, but also by the citizenry of a republic, because that's where the ultimate authority lies. And I'll simply close, if I may, with a quote from Abraham Lincoln, who defied the Supreme Court in questions of habeas corpus back during the time of the Civil War. And Lincoln wrote this: "People will cease to be their own rulers, having practically resigned their government into the hands of that eminent tribunal." We have resigned the government of liberty into the hands of that eminent tribunal. Now more than ever, we need a better jurisprudence than the jurisprudence of Prego.